Dr. Seema, Senior Assistant Professor, Department of Law, University of Jammu. The topic of my presentation is the status of marginalized groups in the state of Jammu and Kashmir. First, let us take a look at marginalization. What do we mean by marginalization? Oxford Dictionary defines marginalization as to treat a person or group as insignificant or peripheral. Marginalization is the process whereby a subgroup is pushed to the periphery. This is predominantly a social phenomenon by which a minority or subgroup is excluded and its needs or desires are ignored. These marginalized groups that are pushed to the periphery, they are not treated at par with the major groups of the society which are in the main strip or occupy the central position in the society. They do not enjoy legal rights at par with those groups with respect to their survival, education, residence, jobs, status, etc. The more marginalized groups exist in developing nations. Women, people with disabilities, Dalits, aged people, children, minorities, etc. are most vulnerable marginalized groups in almost every society. Marginalization of a particular community or group puts so adverse an effect on people of that community that they land up in an identity crisis, pushing them to an overall backwardness. So how we can then remove this marginalization? It is by empowerment of these subgroups that their marginalization can be addressed. As far as the state of Jammu and Kashmir is concerned, there are 4 marginalized groups that are still the victim of the state callousness. First, the West Pakistan refugees. Second, the Valmikis. Third, the Gorkhas and the women of the state of Jammu and Kashmir. First of all, the West Pakistan refugees. The West Pakistan refugees migrated from West Pakistan, that is pre-partition West Punjab, to the state of Jammu and Kashmir during partition of India in the year 1947. They have been living in the state for the last 70 years. Now, the reasons for their coming to the state of Jammu and Kashmir were that there's a many time asked question, why these West Pakistan refugees migrated to J&K and not to Punjab? The reasons for that are, 1. Jammu in J&K, where the refugees migrated from Sialkot, it was nearest for them. It was only 38 kilometers from Sialkot. Secondly, there were plunderers on the way to Punjab who were robbing these people who were migrating to Punjab area and murdering them. So they found it safe for them to move to Jammu. Third, many of these refugees, they had their relatives in the state of Jammu and Kashmir. So they found it the natural option for them to take a refuge in Jammu with their relatives. These West Pakistani refugees are actually not refugees but the citizens of India. They call themselves as refugees because even 7 decades later, they are still identified as refugees and Pakistanis and denied their basic rights in the state of Jammu and Kashmir. From a few thousands at the time of migration, their population has now grown to about 1 lakh. When compared to those who migrated from Pakistan to other parts of India, it's been seen that all those who migrated to rest of India, they were rehabilitated and as the rightful citizens of India enjoy every right and privilege that the Constitution of India confers on all Indians. Whereas all those rights, they are denied to these West Pakistan refugees who have settled in the state of Jammu and Kashmir. Now coming to the second group, that is of the Valmikis or Safai Karamcharis, the sweepers. In 1957, 272 Valmiki families were brought from Punjab to the state of Jammu and Kashmir, specifically to be employed as Safai Karamcharis or sweepers to meet the acute sanitation crisis which was generated by the indefinite strike by the local Safai Karamcharis. This was in pursuance to a decision taken by the state cabinet in an emergent meeting convened by the then Wazir-e-Azam, who was then called the Prime Minister of J&K, Bakshi Ghulam Muhammad, in which a decision was taken to bring Safai Karamcharis from other states to solve the crisis. These Safai Karamcharis were promised the protection of all constitutional and fundamental rights as guaranteed to the local residents of state of J&K. However, even after 6 decades, their plight remains unchanged. The number of their families has now increased, but the increased means the increase only of the Safai Karamcharis for the state, as they cannot take up any other profession in the state despite being qualified. When they were brought to the state of Jammu and Kashmir, a provision was introduced in the State Civil Service Regulations which provide for the entry of only the permanent residents of the state in the state services. Only a relaxation was provided for these Safai Karamcharis, that they will be treated as the state subjects only to the extent of being the Safai Karamcharis. So, any generation of the Safai Karamcharis in the state of Jammu and Kashmir can be the Safai Karamcharis only. Such is the state of affairs that the residential colonies allotted to these Safai Karamcharis since 1957 have also been not recognized till date. The third group is that of the Gorkhas. The Gorkhas came and settled in the state of Jammu and Kashmir during the reign of Raja Gulab Singh, the founder of the Dogra regime, that is, from the beginning of the Dogra regime in 1846. The forefathers of Gorkhas now residing in J&K had sacrificed their lives in the formation of the J&K state. Successive generations of many Gorkhas contributed towards expansion and consolidation of Jammu and Kashmir state. Colonel Durga Singh, Indian Order of Merit, a Gorkha officer by birth and highly decorated officer, his grandfather Rana Kharak Singh and his father Subedar Lal Singh all contributed in several campaigns that were undertaken by state forces for expansion and consolidation of the state of Jammu and Kashmir. For the great show of gallantry displayed as part of J&K State Force during World War I and World War II, they were rewarded by the Dogra rulers with jagirs and agricultural land, so that after their retirement, they could live comfortably in the state and look after their families respectfully. Gorkhas hold a glorious history in the Jammu and Kashmir state prior to independence. Apart from being good troops, they have proved to be good leaders as well. This has been recorded on the regimental history of Jammu and Kashmir Rifles, the erstwhile J&K State Force. During the Pak invasion of Kashmir in 1947, the Gorkhas of Jammu and Kashmir acted with undaunted, unsurpassable courage and showed exemplary devotion and conspicuous gallantry in the face of enemy. Brigadier Sher Jung Thapa was awarded the much coveted award of Mahavir Chakra in recognition of his gallantry, inspiring leadership, tenacity and selfless devotion to duty during the battle for defense of Skadu Fort. Though Skadu is not a story of victory, but it is of gallantry of a Gorkha officer who fought for the state of Jammu and Kashmir till his last breath. However, in the Pakistan invasion of 1947, the Gorkha community also suffered the most grievous loss. A large number of Gorkha Jawans were killed in the Pakistan invasion in 1947. A large number of people of their community were killed by the tribal raiders, followed by Pakistan invasion of J&K state. A huge mass of widows and orphans of their community was left with nothing to bank upon and were forced to live almost a nomadic life. The Gorkha community, which contributed immensely in keeping the frontiers of J&K safe, today is struggling for a life of dignity in the state of J&K. The deplorable conditions of the current generations of those brave hearts would send any heart to torments. Now the fourth group is of the women of the state of Jammu and Kashmir. Women in the state of Jammu and Kashmir face the severest kind of discrimination. The women of the state also have been subjected to discrimination in the matter of permanent resident status. Men of Jammu and Kashmir state who marry outside the state can bring home their wives who become entitled to the permanent resident certificate, that is the PRC, on marriage. Children born from these women also inherit permanent resident status. However, women from the state marrying outsiders cannot bring home their husbands. a man from another state marrying a woman from J&K state and their children cannot get PRC. So much so that by virtue of an executive order issued in 1965, the PRC issued to women was marked as valid till marriage, and after marriage the PRC in husband's name was to be made. It was in the year 2002 that the women of the state won in the J&K High Court the right to retain their PRC or permanent resident status even after marriage to a non-permanent resident man. The J&K High Court, in its October 7, 2002 judgment in the case of the state of Jammu and Kashmir versus Dr. Sushila Sani, ruled that a daughter inheriting her permanent resident status from her father would not lose it on marrying a non-permanent resident man. However, J&K state legislature attempted laws to nullify the 2002 judgment. Attempts have been made by the state legislature to do away with the judgment of Sushila Sani by introducing the two bills in the state legislature, Permanent Resident Disqualification Bill of 2004 and Permanent Resident Disqualification Bill of 2010, which seek to disqualify women from their permanent resident status on account of their marriage to a non-permanent resident. The bills of 2004 and 2010 could not be passed and made into laws, and the 2002 judgment stands, but the discrimination remains because their children are still not taken eligible for PRC by the state government, which means they shall remain deprived of all the rights available to the permanent residents. Now the question, what the deprivations these various marginalized groups face in the state of Jammu and Kashmir. These marginalized groups, they cannot own any property in the state. They cannot be recruited in the state services. They are not entitled to state scholarships. They cannot seek admission in any state-run professional colleges. They cannot have local political representation in state assembly elections, elections of rural and urban local bodies, because they don't have any voting rights in the state. They cannot benefit from various social welfare schemes launched by the state government. The Valmikis and 80% of West Pakistan refugees who belong to reserved category do not get the benefit of reservation and other schemes meant specifically for the reserved categories. After the Sushila Sani judgment, the women have been held to be equal to men in the matter of inheriting permanent resident status. However, the spouse and the progeny of such women are not entitled to above benefits. Now, what steps have been taken by the government for ameliorating the condition of these marginalized groups? As far as West Pakistan refugees are concerned, the state government constituted in the year 2007 the Vadhva Committee. The Vadhva Committee identified 5,764 families of West Pakistan refugees settled in the state of Jammu and Kashmir in the year 1947. It recommended that the provisions be made to provide the basic amenities to the West Pakistan refugees. As far as the question of granting permanent resident status to them is concerned, the committee suggested that it is a political question and is to be decided by the state government. As far as union government initiatives are concerned regarding West Pakistan refugees, since 1994, Union Home Ministry has requested the government of J&K to take steps to grant the permanent resident status to the West Pakistan refugees. Parliamentary Standing Committee on Home Affairs in its 183rd report on 22nd of December 2014 and Parliamentary Standing Committee on Home Affairs in its 193rd report of 22nd of December 2015, Parliamentary Standing Committee on Home Affairs in its 183rd report of 22nd December recommended one-time settlement for these West Pakistan refugees, and the Parliamentary Standing Committee on Home Affairs in its 193rd report, Parliamentary Standing Committee on Home Affairs in its 183rd report of 22nd of December 2014 recommended one-time settlement for the West Pakistan refugees, and in its 193rd report of 22nd of December 2015 confirmed the one-time settlement for these refugees. Disbursement of Rs 5.5 lakh per family by Union government as one-time settlement is in process at the moment. As far as Valmiki's, Gorkhas and women are concerned, no initiatives by government, whether be the union government or the state government, have been taken as yet. The deprivations and disabilities faced by the marginalized groups of West Pakistan refugees, Valmikis, the Gorkhas and the women in the state of J&K clearly show that they are seriously facing human rights violations and the violation of fundamental rights guaranteed by the Constitution of India. The Constitution of Jammu and Kashmir provides for the directive principles of state policy under its sections 11 to 24, which enjoin upon the state to make welfare measures for the marginalized groups. However, the state of J&K has acted in utter disregard of the directive principles of state policy. What legal recourse these various marginalized groups have taken for the protection of their rights? West Pakistan refugees approached the Supreme Court of India in the case of Bachanlal Kalgotra versus State of J&K in the year 1987. The Supreme Court of India recognized the rights of the West Pakistan refugees and suggested that the state legislature should make measures by way of law for providing basic amenities to these refugees. However, as far as the granting of the permanent resident status to these refugees is concerned, the Supreme Court of India again threw the ball into the court of the state legislature. Now, presently, another petition with regard to West Pakistan refugees has been filed in the year 2015, which is the West Pakistani Refugees Action Committee of 1947 versus the Union of India, which is pending before the Supreme Court. Regarding Valmikis, Radhika Kil versus Union of India is a writ petition which has been filed in the year 2017. Regarding women, the recent cases, the Charuvali Khana versus Union of India, a writ petition which has been filed in the year 2017. Regarding women who marry outside the state of J&K, the claim for seeking the rights of the progeny of such women has been laid in the case of Charuvali Khana versus Union of India, a writ petition of 2017. The constitutional and legal provisions under challenge for such deprivations suffered by the marginalized groups are 1. Article 35A of the Constitution of India, which bars any challenge to the conferral of special rights upon the permanent residents of J&K and discrimination of other citizens on the ground of violation of fundamental rights. Part 3rd of the Constitution of Jammu and Kashmir, comprising of sections 6 to 10, which gives the definition and other provisions dealing with the permanent residents of J&K. The constitutionality or legality of Article 35A and Section 6 is under challenge in the Supreme Court of India. In the writ petition, We the Citizens versus Union of India of 2014.